I recently issued 2 applications for prosecution in the Magistrates Court against 2 police officers. But before I give you the details, let me tell you the outcome of my first prosecution. I published on my website a full account of my bid to bring PC Mark Knights to justice, the police officer who thinks it's okay to headbutt members of the public in the face if they take rightful offence to his insults. If you haven't read those articles, please take a look. But the short version is that the CPS have taken over the prosecution with the full intent of trying PC Knight for common assault. On the 20th of August, I entered into a conference call with Derby magistrates where the judge informed me that PC Knights had entered a plea of not guilty and the case had been sent to trial for the 2nd of December. As far as I'm concerned, this is a good outcome, irrespective of what happens at the trial, because without my efforts to privately prosecute Knights, he would have escaped all charges. This is because the Professional Standards Department of Derbyshire Police conducted a deliberately defective investigation as a means to exculpate PC Knights. Helping corrupt police officers evade accountability is something that Derbyshire Police, like most police forces, excel at. The standard process is that the police drag out the investigation until it goes over the 6-month time limit to prosecute for most offences. That way, in the unlikely event that they find the officer committed a criminal offence, any opportunity to prosecute him will have passed. It was only because I brought the prosecution before the 6-month window ended, the police weren't able to assist with getting one of their own kind off the hook. And so we move on to the next prosecution, PC Paul Cotton and PC Lauren Buckle. These 2 charming individuals were responsible for falsely imprisoning a teenage lad and submitting him to an earful of threats and abuse simply because he legally crossed the road in front of their police vehicle, causing them a massive inconvenience of having to slow down.
Just listen to what I'm saying. Actually, we've stopped you to give you some safety advice. Yep. Your attitude and everything else is I don't give a fuck. That's what it comes across to
Straight
me.
away, excuse me, you'll respond to us, what? So don't talk to us about attitude. If you want, I'll put you in the car and we'll take you to your parents. We'll have this discussion and we'll start serving you a community protection warning, shall we? Banning you from going places.
For crossing a road when I'm confused whether the car is accelerating or decelerating, but I still had enough time to cross.
Well, you didn't because you caused the vehicle to stop. So we've proved, haven't we, that, and your attitude stinks.
When his father attempted to lodge a complaint, the sergeant dissuaded him by suggesting that the officer's behaviour was not misconduct and therefore a complaint was not worthwhile. It wasn't until I published a video about the incident that Staffordshire Police took notice and then tried the standard brush-off tactics by inviting the complainant to an informal sit-down as a means to dispose of the complaint and avoid having it officially placed on record. The victim told me that senior officers attempted to buy him off with, get this, a box of sweeties. Yes, it's true that the police place public outrage in such low regard they think it can be placated with a box of sweeties. Apparently the box had the words, "You're the best," emblazoned across it, in print I might add. There's no doubt Staffordshire Professional Standards have a warehouse full of cheap bribes they palm off like Santa's grotto. I already made it clear to Staffordshire Police a number of times that if they weren't willing to hold their officers to account, then I'd do it for them. And now it seems that duty falls upon me as I formally charge PC Cotton with a Section 5 public order offence and the indictable charge of false imprisonment, and I've charged PC Lauren Buckle with a Section 5 public order offence, false imprisonment and careless driving. I gave both officers the opportunity to be interviewed under caution prior to issuing the charges, but both officers ignored my request, and so it now remains to be seen whether or not there will be a pre-summons hearing. One last comment I have to make is that senior officers at Staffordshire Police, when confronted by the victim, seemed more interested in finding out as much as they could about me, in the hope that they could prosecute or sabotage me for some imagined offence in their own twisted imaginations. It didn't surprise me in the least to hear that I was being subjected to scrutiny by senior officers, rather than them subject their subordinates to the same scrutiny. So once again I find myself on the treadmill of private prosecution, but this is something I'm going to be getting used to. As I've already said in the past, the only way of truly holding criminally minded officers to account is through the criminal courts. And it's thanks to those who support me that there now exists the Crime Barge Prosecution Service, the only truly trustworthy public service that's genuinely interested in holding corrupt officers to account.